All right. It's a bit late, but as I have said before, I do hope I can keep my earlier promise and get this to you by the end of the day. Um, I just want to make some introductory remarks, sort of set the framework for the civil rights cases that are our next readings and subject. Um, this is, just a remarkably loaded case, and hopefully I can just say some things about the framework, and then perhaps a little bit about the argument that the court makes. Extremely, not just influential. I think, in a sense, it just very much mirrors a deeply held political ideology in America at that time. And we'll also look, of course, at Harlan's extremely interesting and provocative dissent. Um, Harlan's dissent probably won't come up today. All right, what's going on? Well, there is some congressional legislation that is being challenged by private citizens. But before we get to that legislation, a little bit about where we are in history and what's going on in America at the time. This case occurs at the very center of Reconstruction, this rare chapter, extraordinary chapter in American history, when there was real effort on the part of those in political power to try and bring about political equality for the newly freed slaves. It's just a remarkable effort backed up by the army, as was absolutely necessary. I think it's in 1877, a political deal is brokered, and exchanged for Hayes becoming president, the troops are withdrawn from the South, and Reconstruction ends. It's about a 15-year experiment. A lot of interesting things, are said about it, the degree to which it did succeed, the degree to which it didn't. That's not our issue. But this legislation is so clearly saturated with the spirit of Reconstruction. Okay, let's say a bit more as to how. What's in the background? Well, there's a 13th Amendment and a 14th Amendment. The 13th Amendment, as many of you know, I am sure, actually just abolishes the institution of slavery, renders it no longer legal within America, no involuntary servitude, except, of course, what follows from conviction of a crime. The 14th Amendment, which will occupy us to a much greater degree in this case, the 13th Amendment isn't utterly invisible either, as you know, if you've read the case. The 14th Amendment essentially requires the government, both the federal government and the state, to treat its citizens equally. I looked up the exact language, and here it is. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens and of the state wherein they reside. Here's the important sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any persons within its jurisdiction the equal protection of the laws. All right. It's that point about not denying to any of its citizens whatever privileges or immunities it extends, and not denying equal protection of the laws. The 14th Amendment requires states to extend equal application to whatever laws it has. So, to give an innocuous example, and this is quite in accord with federalism, the way in which, the federal government is going to tell states what the exact content of their laws must be. If a state wants to say people can marry at 16, that's certainly something they can, and another state says 18. This is just absolutely acceptable. The thing is, no state can have that rule true for some of its citizens and not for others. No state may extend privileges or immunities to some it denies to others. All right, that's one fact in the background. Now, Congress is empowered to enforce the amendments of the Constitution by the legislation it deems fit and suitable to enforce these constitutional amendments. And so, pursuant to its power under the 13th and 14th Amendment, and this is real Reconstruction Congress, Congress passes this law. It's truly mind-blowing that this happened. It's like the most ambitious anti-discrimination law you've ever heard of. It's even more ambitious than what Johnson gets passed in the mid-1960s. And if you read the case, you know it becomes a crime for a landlord, the owner of a funeral parlor, amusement parks, I believe. In fact, I'm kind of virtually sure even schools may not deny the service or the good to any citizen on the basis of race. It actually says that. Racial discrimination in the purveyance of these goods is made illegal. It's just remarkable. And as I say, it even includes education, which was always seen as having a special status in various debates along these lines about access to public goods, like, a hotel room and so forth. But in any event, so this is the tiers of the legal posture. You have the 13th Amendment of the Constitution and the 14th Amendment of the Constitution. And then you have Congress's power to enact legislation that it believes is necessary for these constitutional amendments to be enforced. And against that justification, this particular extremely aggressive law prohibiting acts of discriminatory service provision, it's a decent way to put it, is then understandably challenged by the we'll just say the landlords. The landlord can stand in for the amusement park owner and the funeral parlor owner and public in the sense that it's open to the public, but obviously insofar as bus lines and carriage lines were going to offer services to citizens, these too can't offer their services in discriminatory fashion. Can you imagine? Like in 1875, Georgia, a law like this, where a hotel owner could not refuse service to a newly freed slave? This is just out of this world. Well, okay, the hotel owners challenged the legislation. Why? Well, they say the 14th Amendment says no state may treat its citizens unequally. No state may abridge or unevenly distribute the privileges and immunities it makes available to some of its citizens. But we're not the state. I'm just a private guy with a hotel. I'm not the state. My behavior isn't covered by the 14th Amendment. Congress has no right to legislate my behavior when the 14th Amendment specifically prohibits the state from acting in a discriminatory fashion. And this isn't state behavior. Yeah, the state can't say only whites can get married, only whites can own property, only whites can have wills. That would violate the 14th Amendment. That's clearly prohibited. But if I'm just, in a way, rude, if you will, to my African-American neighbor, you can dislike it or tell me, all kinds of moral things about it, but it can't be called state action. That's the argument. The behavior of the landlords and, amusement park owners is not state action, but private. Now, this is a big, big deal, this argument and how we feel about it. To what extent or in what respects is it in fact true that a hotel owner behaves in a way that may be rightly characterized as thoroughly private? To what extent can we say that the hotel owner is, nevertheless, in some sense, an agent of the state or entwined with the state. Well, you'll see some of the arguments to that effect in Harlan's dissent. But, and this is what I meant at the very beginning when I said I just want to supply a bit of a framework. Because for us to pursue this issue, how are we to understand the private act versus the act of the state, is to also have to back up a bit and just think about, the contingencies of our distinctive culture and how we happen to do things in America, which shape how we see these things. But it's hardly inevitable or natural that these things be done this way. So to just give an example, consider something like Con Edison. Is this a private or a public entity? Well, it's certainly private in one sense. It's a for-profit corporation. It's not the post office. It's not actually run by the government. These entities, Con Edison, railroads are like this, are often given charters or licenses to provide a service that is deeply entwined with the public good. Electricity or, train transportation. These things are extremely important to ordinary life, from 19th and 20th century, the Western world. And some countries would just provide these directly from the government. And other countries, like this one, is content to, as it were, outsource these deeply important parts of ordinary public citizenship to private owners. So you have to also, when you're thinking about whether these actions are private or public, you have to think about the way in which certain services and goods like electricity and rail transportation, and there are many such examples, are very important to public life. And it would be very hard to imagine these goods being somehow distributed unevenly or in a discriminatory fashion. I'm not saying it's hard to actually imagine. It's hard to imagine that being in any way acceptable. These are very important phenomena. Nevertheless, the public-private distinction, that's the important point that I just want to alert you to, is extremely obscure or hard to fully delineate in the American context in cases like this. Another consideration I might as well mention is that of licensing. Insofar as the state licenses an enterprise or business enterprise, it's arguable that it makes the very possibility of that enterprise. And so, consider two amusement parks, one of which has been and one of which has not been inspected by the state and certified as safe. And so one says, inspected by the state and certified as safe, the other can't say it. Well, which do you think will have the better business? What's the odds of being able to survive when you can't say you've been certified as safe? And obviously, there's a very similar point about restaurants and a very similar point about hotels, that they're licensed and in some sense judged acceptable or not dangerous. This is a not insignificant part of how it is that these private enterprises can be in business in the first place. So there's this very rich, deep set of considerations that have to be borne in mind when thinking about how to understand the hotel owner's claim or how well you want to assess the hotel owner's claim. I'll just go over them again. We'll rehearse the hotel owner's claim and why it means, and the court agreed with this, that the civil rights legislation was in fact non-constitutional in the sense that it was an expression of Congress overstepping its legitimate authority. The 14th Amendment seems to say Congress can oversee whether a state is acting in a discriminatory fashion. It can't meddle in what is not from the 14th Amendment. There might be other powers in the Constitution. In the 1960s, the Johnson administration found them. But according to the 14th Amendment, the power is to just make sure the state acts in an even-handed way. And this isn't the state that's being here regulated. So Congress has overstepped its legitimate authority, and this legislation is unconstitutional. That's the argument. Now, as I say, to the contrary, you have to think about the ways in which, when the state licenses these things, it's entwined with these enterprises. You also have to think about the way in which the goods themselves are very much tied in with our conception of ordinary civic life. And it's just a kind of contingent fact that in this country, we privatize, we hive off, or as it were, contract out the purveying of these goods. From the fact that they're provided by private owners doesn't mean our conception of them is as a thoroughly private thing. You know, if somebody didn't want to show me or sell me his very rare South American stamp collection because of some racial or other bias, I'd be inclined to think he's not depriving me of any obvious public good. He is being rude and a jerk and so on. But, my citizenship isn't terribly impacted if, this offer on eBay is withdrawn. Perhaps I'm underestimating it. Perhaps it is more impacted than I think, in the sense that we have to be assured that there couldn't be an infinite number of such occasions. But you see the point I'm trying to get at. I don't want to deny that there would be, under any reasonable interpretation, some acts that would be not state action, that would be not within the reach of the 14th Amendment's enforcement. I mean, the general point, I think, is undeniable. I don't want to say there's no such thing as an act which isn't also state action. That's kind of be nuts. You can draw the line as you like. I think we should be able to agree about certain examples, but we can do that another time. My only point is some version of the state, non-state action distinction is almost certainly plausible. But whether the purveying of things like public accommodation, public transportation, public leisure, whether these things can be thought of as something like some deeply private possession, like, I show you this, signature of Martin Amis I have on my old copy of Money. This is just something that's really mine and has very little to do with state action. It's hard to see any theory of, civic life being implicated in that story. Okay, we'll talk more about this next time. And you really want to read Harlan's Dissent. And, obviously, we want to talk about why the landlords won this suit and why the U.S. Constitution, U.S. government laws. Undoubtedly, there's a racial bias element in the explanation we would settle on, of course. I don't think it's terribly ridiculous to say the court was looking to agree with a justification that wouldn't, in fact, require these citizens in the South to behave in a non-discriminatory fashion. I think that's all true. But I also think there is a theory or doctrine of the state-private distinction here that's just deeply, deeply Anglo-Saxon and sort of almost self-consciously assumed in our political culture that's doing a lot of the work too. It's like, well, sure, obviously, when they meet in Albany and pass laws, that's state action. When the, sheriff enforces a warrant, that's state action. When, a jury gives its verdict, that's state action. But when, I sell you a ticket to, throw a baseball at a Cupid doll, how is that state action? That's the argument, this real almost Americana argument. I mean, what are we talking about here? What is this, communist Russia, where everything is state action? I mean, that's also in here. And although, the racial animus should never be denied, and as I say, this is in the center of Reconstruction, nor should the seductive appeal of this particular version of the state non-state distinction that enables the landlords to prevail in this case. All right, that's the general introduction. Please read it. I used to really think about what would have happened if a few more people agreed with Harlan and this law was found constitutional. I used to think it might have made a big difference. Now I think, well, the government probably just wouldn't have enforced it once they withdrew the troops in the late 70s. But it's nice to realize when you read Harlan and others that a lot of people were very aggressive about making things different. Okay, that's it for now. More later. Thank you very much.